Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alysha, Pannu, and today's episode explores how enforcers approach benchmarking and information sharing and how their approach has evolved over the years in order to adapt to new technologies such as AI. I'm here with my co-host, Panos Dimitrellos. Hi, Panos.
Hi, Alysha. I'm very excited about our guest and our topic today.
As am I. Would you like to introduce today's guest?
Sure. Here to provide an enforcer's take on benchmarking and information sharing is Lee Morris. Lee Morris is the Special Assistant Attorney General in the Consumer Protection Division of the Mississippi Attorney General's Office. He recently published an article for the Antitrust source titled Benchmarking and Information Sharing and Enforcer's Take on this very topic. Lee, we're very happy to have you here.
Thank you for having me.
So to kick things off, Lee, could you tell us briefly about your path to antitrust enforcement and how you came to develop an interest in benchmarking and information sharing?
Absolutely. Thank you again for having me. It's great to be here. I love the title of this podcast too, because it is an amalgam. And I was at a fall forum this past year, and Judge Bellari was like, hey, we need to hear from all different kinds of voices, not just the same old faces, but I would like to call myself a new face to antitrust. And my amalgam is a different one because I studied economics in college. My thesis advisor, Dr. William Shugart, he was an FTC economist when he first started, but he became this great antitrust scholar and took me under his wing, and I really just loved spending time with him and took as many classes as I could from him. But it was really hard to see, like, okay, how can I make a career out of this, especially in Mississippi? And I also happened to take my first antitrust law class with Gary Myers, who's now at the University of Missouri Law School. He was also so kind to me too. And I first took an entertainment law class with him. And okay, I saw that he's got this other class, the next year, and wasn't really sure what it was all about. It was called Intersection of Antitrust and Intellectual Property. I completely loved it. And so that kind of embarked my law studies, and I went off to Chicago and went to law school at DePaul. But in that amalgam, strayed from antitrust a little bit. During law school, I worked in the area of research administration. And so I was managing and applying for grants, research grants in the areas of cancer research and public health at Northwestern, and really loved it too. Was blessed with some great team members there. But when the time came for me to move back to Mississippi, where my family is, this opportunity came up at the Attorney General's office, and the job description just basically said, antitrust attorney. And I was like, I didn't know that you could do something like that in Mississippi. And I really am also, again, blessed with a great team and great mentors as well. So I've really just been kind of riding this great streak, and I get to practice law in Mississippi and think about economics all day. And but specifically, I'm on the Consumer Protection Division. And so that's a really good position to be in terms of making a big impact for Mississippians and also people across the country as well, since we work with other attorneys general across the country. So, I have the privilege of being able to give presentations on human trafficking, and my colleagues are also really great with telemarketing scams and local enforcement issues and other outside counsel issues as well. And so I really enjoy working with them, but also attorneys across the country on some of our multi-state litigation that we have. And so, but in terms of economics, I think of this issue at hand today, the benchmarking and information sharing, really reminds me, it goes back to my game theory course that I had as an undergrad, where, it is like an information game of what does this other entity know, and what do they know that you know, and it can create tremendous implications for complete perfect information, which is scary in terms of competition. So I think it has significant implications on information in markets, and it can absolutely sway consumer behavior and market pricing tremendously.
So before we go deep into our topic, I have a two-part question. So first, how should our audience understand algorithmic benchmarking and information sharing in general, in a few sentences? And is the state attorney's general perspective in general identical to the DOJ's in this topic, or there are differences? And if there are differences, which are the main ones?
Absolutely. So the first part of your question, I like to think of it as, I won't name names, but let's just say there were two major hamburger chains, and they were competitors, and had no knowledge of each other's pricing information or customer base, et cetera, et cetera. Imagine if they subscribed to a service that solicited this information, stored it, audited it, and also disseminated it in a instantaneous and seamless way. Hamburger chain number one could see hamburger chain number two's pricing information and realize, oh wow, I'm not charging enough for hamburgers. It looks like I could get away with charging for more. And you don't even have to single out hamburgers. You could stick in any industry there. And so you would like to think, okay, they're going to use this information for good, and they will therefore work together and pass along savings to the consumer, and it's going to be a great day. But unfortunately, human nature tends to take over sometimes, and information that's being shared across the board like that can lead to price fixing, which can have tremendous social cost. You have basically deadweight loss. So consumers who choose not to pay at a higher price due to that lack of competition between those competitors, or who should be competing. You also have the rent seeking that those companies also engage in to maintain this price fixing scheme, and so that can entail lobbyists, legal fees, other administrative costs that otherwise that could have gone to something else in society. And then you have the absolute loss of consumers who do choose to pay those higher prices. So they are hurt by that as well. So it absolutely affects the consumer in ways that they can't possibly see from a day-to-day basis, because it's such a seamless, instantaneous way. Today it is, thanks to technology that is progressing at such a rapid rate. In the olden days, and sadly that's not that long ago, it was much harder to price fix, and it was much easier to show because there was a paper trail of phone calls and faxes and meetings and so on and so forth. So today the price fixing algorithm is very difficult to unpackage, and a colleague has said unscramble eggs. So and yes, and our office's view, I think, like DOJ's, is evolving, because it is the issue itself is evolving and complex and nuanced. And I really commend DOJ on taking these steps they have in the last few years, from removing the old safe harbors and addressing head on exactly the nature of the problem, which if not addressed, it will completely go out of control. And I would like to think of it as an expressway to monopoly. So it definitely is something that our office is very concerned with, and but thankfully we have a large network of other attorneys general and our federal partners as well, and we can all work together on addressing this issue.
Thanks, Lee. Yeah, it's certainly an issue that's very important for consumers. Courts have generally treated information exchanges under the rule of reason rather than as per se violations. So in in plain terms, what does this mean for investigators, such as yourself or enforcers that are trying to show harm when algorithms and real-time data are involved?
Absolutely. So in plain terms, it's a much heavier lift using the rule of reason approach. Unfortunately, it not often is able to be shown on a per se approach, which you could just show that there's an exchange involved, and then you've got your box checked off. So burden of proof is much higher. So you have to prove that it actually caused or is likely to cause a deleterious impact on competition. And so this requires a very deep fact-specific dive into the industry, involving economists and experts, and it's a very long process. But you really have to analyze the market conditions, both before and after the information exchange, to really make sure that the trade has been restrained. So that's critical to see that difference. But even if there's not a signed contract or an explicit secret handshake, you can still show collusion through the shared actions of different companies in that sense. And one example you can see from the RealPage litigation. So you see multiple competitors feeding their sensitive data into the same real-time software, and that acts like itself. That act itself can be seen as a conspiracy, and by letting an algorithm set the pace, the companies basically just destroy the independent decision making that the Sherman Act is designed to protect.
So Lee, as someone with an economics background, can you explain us which are the mechanisms that make modern real-time benchmarking more likely to facilitate collusion than old-style mechanisms? And in practice, what are the empirical indicators that you will look for in a real case?
Well, I feel old thinking about the old-style slow surveys, because that you think like, oh, it was so much easier back then, but it's no longer the manual over 90 days old kind of process, which really made collusion difficult. So you kind of have to hand it to people for colluding in that way, because think about the coordination that it took compared to today, where it's literally a click of a button. But today, algorithmic tools, it's near instantaneous on pricing and inventory, and it allows competitors to basically synchronize their moves. And to borrow a phrase from the Agri Stats litigation, it's like a single accounting department for the entire industry. What also makes it more tricky is you might see claims of, oh, this data is anonymized, right? And you can't tell where it's coming from. But AI can really use predictive analytics to de-anonymize that data and identify where it's coming from, like who are the specific competitors, what are their future pricing trends. So that also removes the need for any direct person-to-person communication. Another term that we have from AgriStats is this producer realm. So that would be, who is at that producer level in the chain of operations. So I think it's important to look at that and see who has access to that. So if sensitive data, it's only being kept in a certain realm, for instance, like the producer realm, rather than being shared with the public itself, that's a major red flag that the information is not being used for pro-competitive purposes, but it's being used to gain like an unfair advantage over consumers. So also to that point, the issue of recency. And so the old safe harbors said, okay, data that is more than 30 days old, okay, that's less risk. Unfortunately, that's also no longer the case. So, as I mentioned with the de-anonymization, also you can go back and use that predictive analytic technology to see where that old data is heading. So I think anything that's is on the table, but especially data that's less than 30 days old, that's way more high risk. And I'd say the fresher the data, the more it can be used to manipulate the current market prices. So also, if a single software aggregator, if they control the majority of a market, its recommendations for prices, that are automatic, they can quickly become an industry-wide price floor that everyone follows. And if you think about one landlord has one property, they rent it out as extra income on the side. They can have time to accept or reject that recommendation. But if you're looking at a large company, they may be getting hundreds or thousands of recommendations, and it almost defeats the purpose to really sit there and evaluate the recommendation. They trust that, and it's very tempting to accept the recommendation from the system that is the all-knowing, all-seeing. And so I think it can really quickly become the price floor that everyone will typically follow. Last thing I'll say on this is that when companies exchange non-public details, like really competitively sensitive information, like profit margins or supply levels, beyond what you might have access to just via the internet or Google, that has a necessary tendency to kill natural competition and inflate prices, for sure.
So nowadays, when a third-party vendor collects and redistributes competitively sensitive data, how do you think about whether this distribution is a considered action under Section 1? For example, does the vendor's profit motive or lack thereof matter?
Right. So I guess just to start, Section 1, Sherman Act, that targets any contract combination conspiracy that holds back trade. And so when companies use a third-party vendor to swap sensitive data, DOJ has expressed their views that that is a joint commitment to work together rather than to compete. So here's how that acts in the modern world. So the act of sharing sensitive information, that's often enough to qualify as a concerted action when independent competitors engage in what you would call intimate and continuous cooperation. And when they do that without any good reason, that creates a very strong suspicion of conspiracy to manipulate prices. So there's your first flag there. Also, you have to really think of the algorithm as a hub, in a sense, hub and spoke. If you look at your tire wheel and the center part, and the little spokes that go out would be each company that's engaged in this. So using that, using a modern algorithmic tool to facilitate these exchanges, that is unlawful whenever it starts to choke out competition. So, whenever a third-party vendor, whenever they don't have to profit, it still doesn't excuse them. Just because they're not profiting, they are still part of the problem. And even if a third-party vendor, such as, go back to our hamburger example, you have Johnny's information sharing company. Johnny he has no skin in the game, but he is the central hub for competitors and also their data. and that's facilitating collusion in that sense. So, um, the hub in this situation, going back to AgriStats, to use their term, it's the industry accountant, and that's timely since at the time of this recording, we're a week away from tax day in the U.S. And think about how specific an accountant's knowledge is with their client's business. I mean, they know everything there is that's reportable about their income and deductions, et cetera, et cetera. That's also scary to think of the hub and spoke situation as the industry accountant. That's well beyond just a few little price points that could lead to collusion. In a way, it's almost like a merger if you think about it, because it's a meeting of the minds, in a complete meeting of their information. So when a vendor acts as a shared accounting department, that also is a major red flag. And last thing I'll say, so this will come up a lot. I believe it's from the AMP oil case, but they talk about the necessary tendency. So necessary tendency of something to destroy competition, but in this case, there is that necessary tendency of the data sharing to destroy this natural competition that the public relies on. That arrangement, strongly believe that that's an illegal restraint of trade, regardless of where the vendor lies in that situation.
So, Lee, in terms of proof, what evidence do prosecutors or civil enforcers find most persuasive in these cases? Are there any surprising sources of evidence that you find persuasive?
Absolutely. What's most surprising is the breadth of data that is actually very, very critical in the situation. It might look, to you or I, like just, a bunch of random figures that have no inkling or no significance, but it may not look like a smoking gun, but it really can lead to one. But in modern benchmarking cases, you look at the data itself and the patterns that the data creates. So at a high level, this is kind of what we do when using that evidence. So you look for the instantaneous market activity. So you're not really looking for, at least initially, you're not looking for phone calls or evidence of meetings or things like that, although that certainly can help supplement the evidence. But it's more the algorithms that are the ones who are doing the meetings and the talking in effect. But when competitors synchronize these prices in real time, that itself suggests a joint commitment, even without a physical paper trail. So I think that's really interesting, because we're really evolving in terms of how we investigate these claims and these complaints. But another specific example, like in RealPage litigation, evidence is found in that software's ability to use non-public data to adjust the prices on a daily basis. And so it's technology that's very constant, high speed, and I believe that is a clear sign of a conspiracy to fix prices, or at least it can lead to that. Also, even if a company claims that their data is anonymous, like I mentioned before, you can easily de-anonymize that. So investigators should also look for that type of software that distills old or unorganized data to clear insights that identify exactly what a competitor is doing. So, and maybe they just happen to have that software in their computer and haven't used it. But I think that's a great place to start looking as well. Another huge indicator is the exclusivity portion. So, you see this in AgriStats. If a benchmarking firm refuses to share sensitive data with the public, and it only sells it to producers, i.e., the competitors, people who should be competing with each other. I feel like that's a sign that the system is pitted against the consumer, and it's not going to lead to more competitive prices. It's going to lead to higher prices, or at least uncompetitive prices. And I think of the linseed oil case again with this. So, one of the most persuasive proofs in this situation is the actual impact itself. And, you see that during different crises in American history, coming out of COVID, firms took advantage of that and agreed to price fix. And people were in a hard spot, and sometimes they don't have the means to fight that or to do it. They're stuck between a rock and a hard place. So the impact is also very critical. But going back to the linseed oil, where there's a necessary tendency to kill competition, they used the quote to destroy the kind of competition to which the public has long looked for protection. I think that that to me is the most profound one, because that's why we're here. That's why I love working on the consumer protection division. Is I get to work with people and work for people who are neighbors and friends and family, and even at my wedding reception, we were talking about an antitrust case this past summer that was happening. So, but it's an awesome time to be in this industry for sure.
So we have touched upon the terms of recency and selective access as risk factors. So how should we evaluate them? For example, is there a rule of thumb that will make them even riskier? For example, weekly or daily data, is it automatically suspicious, or does the context matter?
Absolutely. So context does matter. So modern antitrust investigations, they identify data recency, strong critical risk factor, as algorithms can distill older data into insights that synchronize market activity, and that renders like the 3-month traditional safe harbor from the 90s, that renders that obsolete basically. The key indicators of anti-competitive and high-frequency restricted data practices, that can include a few things like the suspicious timeliness, so that the data that's recent enough to impact the market, that information shared within 1 week of a transaction, extremely high risk. I would consider that. Another factor, this daily optimization. So this capability to fine-tune pricing recommendations, especially on a daily basis. And we also see that in RealPage as well, that litigation. That can enable illegal high-speed market synchronization. And as I mentioned earlier, it's almost like a speedway to anti-competitive nature. It tremendously increases that. Another factor is the selective access. So when vendors restrict sensitive data to what you would call the producer realm of competitors, rather than offering that to the entire market, another huge red flag. The last thing, or actually I'll add in two things. Joint commitment. So these high frequency updates, when they're shared, they strongly suggest a joint commitment, especially to stabilize prices rather than improve market efficiency. You can point to a few studies that showed pro-competitive effects, but there's so many instances of prices rising rather than the market becoming more efficient. And the last thing is as I touched on, the market impact. And so that to me is the core legal test, whether these practices have the necessary tendency destroy competition.
Thanks, Lee. This is all really helpful. So looking ahead, how should we balance the social value of benchmarking against the risk of coordination? Are there ways to preserve the pre-competitive uses of data while limiting the anti-competitive uses?
Absolutely. And I touched on this earlier, but it's worth mentioning again. I think of three areas of, you have deadweight loss, the consumers who choose not to buy at a higher price, you have rent-seeking costs, those costs that are dedicated to maintain this price-fixing scheme. That's also another loss. And then the direct private losses. So those who decided not to pay the higher price, that's kind of what you look at when you're considering social value of benchmarking. And of course, it can have the potential to lead to more competitive pricing or more market efficiencies. I think that's the hope, because the technology is here. I think it's futile to try to completely ban it from the landscape. I would love to see that technology used to unleash competition, but technologies in general, it's not useful if it only serves a small percentage of the market at the cost of the consumer, where a disproportionate amount of people are suffering so that a few can benefit in that situation. So to balance this, we really need transparency. Going back to only certain people can have this information, that's not going to lead to more competition. Also, from the sense of fairness, that data should be more public, or at least more accessible for anyone who wants to pay the same price as someone else to access that data. You've seen in Agri Stats, it's alleged that they refuse to allow access to this pricing data to others. And the last thing is, we need this ability to monitor or audit pricing algorithms to ensure that they are indeed pro-competitive. Because I do think at the end of the day, technology is here to help people. And there's a concept in economics, this Pareto improvement. So that's an improvement that at least one person is better off without anyone else being worse off. And so that's the goal. It's a laudable one, but it is definitely something to aim for.
And one final quick question. So for our listeners without a legal or economics background, what is the single most important things you would like them to remember about algorithmic price coordination, and why should it matter for them?
I think of this quote that we've heard, over the last few years, but even possibly more than that. But are you better off than your parents, or your grandparents, their generation? I think that price fixing, especially price fixing algorithms, unchecked, that can tremendously impact the quality of life and aspects of life that we take for granted. Like home ownership or affordable grocery bills. Heaven forbid you want to go to a hotel every now and then to go on a vacation. But these are all things in the media that you can see are subject to these pricing algorithm investigations. And it is the express way to higher prices. And if that becomes the norm, then all of those social costs that I've mentioned are just going to be built on top of each other. And in a few generations, you'll look and see such a tremendous difference. And we talk about the impact of the market. To me, there's no better proof than that. And if you want to be even more specific, you have for people without more of a technical expertise, you don't necessarily need to see people doing it. It can be people from across the world who are intimately connected in a price fixing algorithm. And last thing I'll say that is also really ominous is that the price hikes can happen at such an instant rate. I mean, it can happen on a daily basis or even sooner. And so any chance to plan ahead, if some major event happens in the world, that gas prices might be going up. In this situation, you have no time to prepare for price hikes. They're going to happen faster than a second.
Well, you've certainly given us a lot of food for thought. Something we like to do with our Curious Amalgam episodes is to ask our interviewers a curious hat question, which is just a sort of a fun random question from our virtual hat to get to know you a little bit better outside of the context of antitrust.
And now it's time for the Curious Hat.
So we'll pluck a question out of our virtual hat for you now. So we have a kind of a topical question for you. So if you were offered a free seat on the next space shuttle, would you accept it or not, and why?
I think I would. I love, space nostalgia. Growing up, I went to Space Mountain and Disney World a million times. Also love the David Bowie song Space Oddity. So as long as there's not like an evil computer on the space shuttle, then I'm happy.
So Lee, again, thank you so much for joining us today on this week's episode of Curious Amalgam. And to our listeners, thank you for tuning in, and see you all next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.